Welcome to the Lawyer for Me podcast.
Hello, everyone, and welcome back to the Lawyer for Me podcast with attorney Kim Kollmeyer. Kim is a Missouri attorney who helps individuals and families navigate difficult legal situations, including divorce, custody, and juvenile cases. She works closely with her clients from start to finish, so they don't have to go through the process alone. My name's Sean O'Connor, and today Kim and I are talking about how child custody is actually decided in Missouri. Kim, how are you?
I'm good. Sean, how are you today?
I'm doing pretty well. I know, these things vary from state to state. I'm not an attorney. I don't know to what extent Missouri is different than other states, but, what does custody include in Missouri when we're talking about that?
Well, so we have got two parents, and they, for some reason or other, their relationship is broken down, and they need some kind of order delineating what their relationship with their children is going to look like, what their rights to their children is going to look like. And understand that they're going to have parental rights regardless. Well, there are some limited exceptions that may apply, but for the most part, people are going to have parental rights regardless. But we begin to look at what does the custody schedule look like? What does joint custody is assumed to be in the best interest of the child? The law presumes, it uses the word presumption, that joint legal and joint physical is appropriate. But that's not always appropriate, and it will be the burden of the parent who doesn't feel that that's appropriate to prove why that may be the case.
Got it. You mentioned joint physical, joint legal, two different types of custody or two sides of this. Like, I know we've spoken of it before, but just define that quickly. Like, what's the difference? Joint versus legal. I mean, you know what I'm saying?
Fair enough. So when we talk about joint legal custody, we're talking about decision-making power. We're talking about the ability to make decisions about braces, about medical procedures. We're talking about the ability to make decisions about religion or educational decisions. When we're talking about physical custody, we're talking about the time that you're spending with the child. So I have absolutely seen situations where one parent set up an appointment with a therapist or an appointment with a doctor, and the other parent then called the doctor's office and canceled and rescheduled. And so we run into these situations, and then we're back in court and we're complaining to the judge because how is the doctor's office supposed to work with this family when we've got parents canceling appointments on each other? And how are we supposed to get care, the kind of care the child needs? I've seen situations, unfortunately, more than once, where one parent feels like a child should be medicated and one parent feels like the child shouldn't be medicated. And when the child is with one parent, the child is medicated. And when the child is with the other parent, the child is not medicated. And unfortunately, where we assume the two of them should be making legal decisions and medical decisions jointly, sometimes that doesn't work. And so that would be a situation where the court might have to rethink whether or not joint legal custody is appropriate.
Right. Yeah. I mean, you just touched on something that I'm thinking about, which is, when a court is making custody decisions, like you said, the default or the ideal or the norm is 50-50. But, what's the court actually looking at when both parents are involved? And, you just described what obviously is a potential, there's a conflict between the parents, about medical issues. So how does the court handle that? What are they looking at?
In the court, well, so there are a series of specific factors that the court is looking at in the statute. But the court, I suppose on a more general level, wants to know which parent is going to be more likely to work with the other parent, and ensure that both parents are getting a fair opportunity. But the court is also looking to make sure that the child is being appropriately taken care of in the process.
hmm And how does each parent's day-to-day involvement with the child factor into those decisions?
You will usually see language that the parents are able to make routine decisions when the child is in their care. or emergency decisions when the child is in their care. By all means, if a child has broken their leg, take the child to the hospital. Don't wait to make a phone call first.
Yeah, there has to be some latitude and just, uh, acknowledgement of reality. And you can write a whole bunch of things down, but ultimately it's like sometimes you just got to call 911, or whatever the case may be.
Well, when we frequently end up with a 13-page document for these custody orders, and as long as you make it, they'll find loopholes somewhere. And sometimes I feel like it might be better if we made it shorter rather than longer, because if someone is determined they're going to find a loophole, they're going to find a loophole.
Yeah. Yeah, yeah. Interesting. So, I mean, that speaks to disagreements, and I'm curious, where do disagreements between parents typically come up most often when custody is being worked out? What have you seen?
And I think that it's appropriate to remember that these people love their children. And they're fighting, and you're perhaps seeing what normally would be healthy, reasonable people in a really low spot in their life, and they're fighting because they love their children. But they then begin to fight over who gets the time and who gets to make the decisions, and of course, everybody wants as much time as they can possibly get with their kid. I think sometimes they get so caught up in that fight that they lose sight of what's best for the kid, as they think about what it is that they want, or what it is that the other side shouldn't have. And
Mhm.
it becomes very important to remember, now this is mom, this is dad, this will always be mom, this will always be dad, or whatever that relationship dynamic may look like in any
Mhm.
given case.
Mhm.
And that those figures are not going to change, even though their relationship between themselves may have changed. And it's just really important for the stability of the child to always remember that that's always going to be the other parent. And it would be ideal that the child always adored both parents, whether they adore each other or not.
Right. Well, you touched on it there. I mean, let's talk parenting plans. What is a parenting plan? How do they factor into custody decisions? What's covered? That kind of a thing.
Oh, well, the parenting plan will cover communication, and generally has an admonishment to the parents to remind each other, to not use the child as a go-between, and to not demean one another in front of the child. It will delineate what is joint legal custody or joint physical custody, or perhaps sole legal and joint physical, or joint legal and sole physical, as the court determines is appropriate. Or, the parties may negotiate something different as well. If perhaps one parent lives far away, maybe the parties agree that joint legal, where they make decisions together, is appropriate, but sole physical is appropriate because somebody lives far away. The custody order is also going to talk about how expenses are paid. So we're going to talk about the school supply list, or we're going to talk about the cost of school lunches, or braces are expensive, or summer camp is expensive, and who gets to make these decisions, and how is that going to be paid for? Who's going to carry the health insurance? What happens if the health insurance gets expensive, and who gets to claim the kids on taxes?
Right. Health insurance expensive. What? What are you talking about?
Oh, I think we could do a couple more podcasts on that
Yeah,
one.
no, more on that later. But things are all, we're dealing with kids here in this context, and kids change. Ideally, they grow up, situations change, people lose their job, get a new job, circumstance, people win the lottery, fingers crossed. Uh, you know, when situations or circumstances change, you know, in what circumstances does the custody arrangement get modified in Missouri? Are there specific uh, uh, factors in the statute that point to this, or is it just you need to know it and then make a proposal?
Modification is a legal word. You picked the right word, my friend. So we're talking about a custody modification, and you can pursue a custody modification either every 3 years or in the event of a substantial change in circumstances.
Hmm.
And if you're just looking for a change in visitation, the change in circumstances doesn't even have to be substantial. It can just be a change in circumstances. So if someone has changed jobs, or if someone has a new relationship, or if someone has moved, either side, that is a change in circumstances, potentially a substantial change in circumstances, and that warrants coming back to court. Now, maybe people don't want to have to come to court, and sometimes people get along well, and the parenting plan will usually allow the parents to deviate as long as they're in agreement with deviation. So maybe 5 years has gone by, but they're getting along okay, and the custody plan was every other weekend, but now they're rotating more frequently than that, and then somebody started a new relationship, and the other somebody got mad, and we have that change in circumstances, and we end up back in court.
I get it. I get it. Are there, I mean, speaking of, statutes and, legal terms, you use the phrase significant changes or significant change in substantial. So, so is there a, a list of things that qualify as substantial, or is it like, when you see it?
I mean, I could research that and I could come up with lists, but I'm not aware of a specific list. Now, the statutes have specific elements that they ask the courts to look for. I did recently have a case where we were talking about specifically the word substantial and whether or not the word substantial applied, whether the court was looking for changed circumstances or substantial circumstances. If you are pursuing a change in visitation only, then the change in circumstances doesn't have to be substantial. And in that case, the court found that there had been very minimal changes, but they were sufficient. If you are looking to change the definition, well, change from joint legal to sole legal, or from sole physical to joint physical, or something along that lines, the change in circumstances would have to be substantial. And I think that it would be very case specific as to what counted as substantial. Certainly, losing a job, losing income, moving from one town to another, that's a big change, and that's going to be substantial. I think arguably same job and changing houses, one neighborhood to the next in the same town, same school district, maybe that's a change, but not substantial. But I would have to research that to be sure. Yeah.
Yeah, no, well, I'll wait. You go. No, I'm kidding. Um, I mean, I can imagine too that, it depends on, if you're dealing with a very sensitive child or the child has a particular special set of needs, something that may not be substantial in one family situation might be considered substantial in another, right? I mean,
Oh, you're absolutely right about that.
you know. So, in your experience, right, when people are, I don't know, picturing custody decisions, where does that usually differ from what uh, actually plays out in court? Like, do you see people are surprised that it didn't go a particular way, or are there are there typical expectations that people come to you with that don't play out?
I think that you will often see situations where one parent is exercising a lot more time than the other parent. And then when it comes time for court, all of a sudden the other parent decides to step up their game. And maybe that's a pride factor, maybe that's financial. The law assumes that it would be best for the kids to be spending a frequent, meaningful time with both parents. But maybe that wasn't the case going into it, and one parent stepped it up for a little bit for the litigation, and when the court case ends, then they slip back out of the situation or spend a lot less time. And I absolutely encourage people to document that, please. Get a calendar. I made a calendar for this purpose, where you get a calendar and start to mark the time that you were supposed to have versus the time that was actually exercised. And if you could even keep a short note, just something concise on why, that would make such a big difference in court.
Uh, yeah, that's that documentation. Uh, I mean, I speak to a lot of attorneys, and obviously, there is that, what's the technical term? Evidence. That, you know,
It makes a difference.
yeah, well, and you get into a he said, she said situation, and the judge, I know these judges, there's the, okay, this is just he said, she said bickering versus, oh, I see what you're saying here. There's a pattern of behavior that's been documented, and then that's something that I guess would be actionable.
Well, people tend to get nervous in court.
Mm.
And it always amazes me that I will have people come into my office and they will talk for an hour about all of the things. And then you call them to the stand in court and you ask them all the same questions and they just stop. And I really encourage people to make some notes, which they can't necessarily read when they're on the stand, but certainly they can give to me. Or if someone is wanting to make a statement to the judge, to write that out ahead of time, so that I can have the opportunity to review that, and so that they can refresh their own recollection about what was important that they wanted to be sure that they covered, because evidence matters. And when they sit on the stand and they say, "Oh well, she just hasn't been letting me have my time, and there was that one time, and there was that other time," and they name 3 times, that doesn't look as good as, "Here's a calendar, let me show you exactly what the last 6 months looked like."
Right. Yeah. I mean, we're all guilty of it, whether it's nerves and just that idea of writing things down, not necessarily from okay, I'm playing detective and I'm recording every, misstep or whatever it might be, but just that you forget, and then you're in a courtroom and you're like, oh, wait, what was I going to say? So just that idea of working with your attorney, uh, I'm sure we'll talk more about that uh, in future episodes. Kim, we're up against time here, so I'm going to have to say until next time.
All right, I appreciate it, thank you.
You bet. That's it for today's episode of the Lawyer for Me podcast. And if you'd like to learn more about Kim Kollmeyer and her practice, visit the website, thelawyerforme.com. That's with the number 4, thelawyerforme.com. Thanks for listening. I'm Sean O'Connor. And as usual, don't forget to, leave a review, subscribe, or share a link with someone who might benefit from Kim's expertise. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.